Since the president declared state of emergency in Rivers State, the NBA have not hidden their dissatisfaction with the declaration. In a press statement, they tagged the declaration unconstitutional. Recall that some other prominent Nigerians have tagged the declaration a democratic coup and a tendency to activate military dictatorship under democracy. However, the NBA president have gone beyond mere paper publication. They are, however, requesting that the president reverse the declaration and return Governor Fubara to his office to continue to pilot the affairs of the state.
Mr. Asue Ighodalo, Senior Advocate of Nigeria, thank you so much, President, for joining us tonight.
Thanks for inviting me.
I know there's been commentaries from the Nigerian Bar Association. A lot of senior lawyers have been weighing in on this matter in the middle of all of the conversation. But as soon as the National Assembly also played its own rule in the Section 305, subsection 5 of the Constitution, understanding of what really the president did was coming to light. But from the NBA's standpoint, how do you assess holistically the outcome of President Bola Tinubu's declaration of state of emergency in Rivers State?
I would like you to be specific. What do you mean by the outcome?
Yeah,
so that I know how to answer your question.
There is an administrator right now in place. There are those who say, okay, whatever that has happened with the president, there is a question mark on whether the president could suspend the governor. There is also those who are saying that in the manner in which the National Assembly voted, maybe there are also errors or loopholes in the manner in which they conducted themselves on the day.
Okay. I mean, I'll take them in segments. For us, first of all, the grounds for the declaration of a state of emergency in Rivers State were not in existence as at the time the president made the declaration. It is our view that the facts as presented did not justify a declaration of state of emergency. They did not meet the threshold or the facts and circumstances enumerated under Section 3.5, subsection 2. Now, the next segment is whether, assuming that as lawyers, which lawyers say, without conceding that the president was right in declaring a state of emergency, was he right in suspending the governor and his deputy as well as the House of Assembly? We also went on to say, and still insist, that that declaration too was unconstitutional, because Section 11.4 of the Constitution makes it clear that declaration of a state of emergency does not extend to power of the National Assembly to remove a governor. Now, if you know that under Section 305, subsection 5, the declaration by the president does not really become law until it is ratified by a resolution of the National Assembly. So you understand in what context Section 11.4 of the Constitution says that provided that the National Assembly does not have the power to remove the governor and his deputy. Now, the substance of this is, what is a state of emergency? State of emergency is merely a declaration that allows the government to take extra measures to deal with the situation, either war, breakdown, law of order, or any of the things enumerated in Section 305(2). So it could be abridgment of the fundamental rights of the people. It could lead to maybe government taking possession of people's homes or doing things that would ordinarily have been unconstitutional, but for the existence of a state of emergency. It does not extend to the dismantling of democratic structures in a state where a state of emergency has been declared. And it was on that basis that we also posited that if the act of the declaration itself was unconstitutional, that the ratification of the same by both chambers of the National Assembly cannot cure the defect. And if you go into it further, the Constitution has stated that the National Assembly, both chambers of the National Assembly shall by 2/3 majority ratify it. It means that for you to ensure that the constitutional provision has been adhered to, you must indicate the number of persons who attended the sittings and the number of persons who voted for against or who abstained from voting. So you can't cure that by a voice vote. So a voice vote falls short of the constitutional requirement, because by a voice vote, you're unable to know whether you have met the constitutional threshold for ratification. So the use of voice vote in both chambers also underscored the unconstitutionality of the whole action. So even that quote-unquote ratification by the National Assembly does not meet the constitutional muster, and it is itself unconstitutional.
Yeah, President, let me quickly take you up on a few issues here. And if you look at perhaps that those who are saying there's some emergency laws that are permitted giving an omnibus power to the president to do as he deems fit or necessary in the circumstance. And in fact, there are those who have read subsection 5 of 305 and subsection 6 and said, look, these are issues that are being raised, and when the president sees something as imminent danger, how do you describe imminent danger? But the question right here is that in exercise of the duties of the president, discretion is also being put in some of the clauses.
So there's discretion and there's objectivity. The president cannot wake up on the wrong side of his bed and feel, oh, I think there's breakdown of law and order in a state. I hereby declare state of emergency. I hereby suspend the governor for 1 year. I suspend the sitting of the House of Assembly. I also appoint General this retired to take over. That would be a key on the Constitution.
On one hand, President.
That discretion is not a discretion that is without checks and balances. It must be within the ambit of the law.
So on one hand, declaration of state of emergency, there isn't anything wrong with it, if it's right.
If it is right.
But suspension of
can never be right. Under no circumstance will it be right. So they are democratically elected government, and no president has the power to suspend another democratically elected officer. If you look at section 188, is it 188, I guess, of the Constitution, on how a governor of a state can cease to hold office, declaration of state of emergency is not one of the grounds.
So whatever President Tinubu did last week, Tuesday, is absolute and is done. Nothing can shake it.
I don't think that it will be right to say that nothing can shake it. They can be set aside by a court. And the president can also say, you know what, I realized that I made a mistake. I reverse it, even though it's been approved by the National Assembly. I think we don't need to go down that route.
Is it also fair on him for those who have described his action as undemocratic? Because there are those who say you do not have 100% picture of what the president is saying. He has security briefings, he's seeing a whole lot of things, he's being told this, he's being told that, and there are threats that are being made in the creeks to bring down the nation's mainstay of the economy. Would you have said that the president should have waited?
So when I hear that argument, I only say, what kind of briefing has he also been getting about Benue, Osun, Borno, Yobe, Katsina, Zamfara, Sokoto, where people have lost their lives, where there has been insurgency, terrorism? Is he only in Rivers? You just talked about Osun before we go to this interview segment. And if the president has heard this, can we have some credible things? And as far as I'm concerned, while I may not be privy to the briefing he has received, I can only point to the content, substance of his address, which only referred to two explosions, and the fact of the intractable political crisis between the governor and his godfather. So I'm allowed to look at these issues as presented by the president in his address in appraising whether the grounds for declaration of state of emergency exist. And an objective appraisal of the same comes out with a resounding no. Because at the end of the day, it was all about the governor not being able to settle the crisis after the court judgment, after not taking advice, not doing this, house not sitting. And even though I don't want to go questioning the narrative as contained in that address, the point is that the Rivers problem is being cured with a wrong solution, in my thinking. To me, it's like taking a sledgehammer to your head because of a headache. The measures being taken to address the Rivers problem are overreaching, are extensive, are undemocratic, and above all, unconstitutional.
I mean, you heard the arguments and the defense of Chief Lateef Fagbemi, the Attorney General of the Federation. For you, is that tenable?
Well, to the extent that the content of his argument was not contained in the president's address, I wouldn't want to comment on them. But the fell short of came close, or more like accuse the governor of being behind the violence. And I thought also, if that was so, and if the two explosions that led to the declaration of state of emergency were real ground for it, there was even no time for investigation. They happened within 24 hours. And within the 24 hours, the declaration of state of emergency had been done. How sure are we that whatever briefing the president received had been subjected to proper scrutiny and found to be true? What if somebody just did that to set the stage for the declaration. I mean, what if? So I think it was hasty, it was unjustified.
Would you say that the governor has been unfairly treated?
If a governor has been treated in a manner not contemplated by the Constitution, it would be right to say he's been unfairly treated. But I keep saying that the problem in Rivers State is political, and only a political solution can bring it to an end, not what we have at the moment.
But this is largely, or in part, a political solution. I mean, a political action that the president has taken.
And an extreme political action with legal consequences.
Let me ask you, I mean, the Constitution is just an item in the body of our laws, the ground norm, yes, be it. But there are also elements, or there are also laws in this country that people have cited in his argument to say it gives the president the power, and those laws have not been set aside.
I would like for people to quote those laws and refer me to them. But don't forget that Section 1 of the Constitution said that this Constitution shall be supreme, that any law inconsistent with the provisions of the Constitution shall be null and void to the extent of the inconsistency. And if the Constitution has not given such express powers, and indeed has expressly precluded the National Assembly from removing a governor, then such a law we have found to be in existence must be unconstitutional. But should not be justification for the action that has taken place.
But this action is not novel in itself. We've seen it happen before in our polity.
I'm sure you're not referring to Obasanjo, because that's not a good example. Jonathan declared state of emergency in Borno, Yobe, and Adamawa without touching the governance structure. That is a correct thing to do, because that is in accord with the provisions of the Constitution. I think people's mistake is to have a mindset of the Republican Constitution, 1963 Constitution, and bringing the same into light with the 1999 Constitution, which has no such provision. And when people also argue about martial law is in place where there's a military rule. And there's no military rule in Nigeria at the moment. So we must be able to separate these sentiments and look at the law as it is at the moment, not as it used to be, or as it may have been wrongly applied in the past.
So if there is a precedent in governance and in government policy, Obasanjo's situation was a bad example.
That would appear to be so. Jonathan's example is a correct example, is a constitutional example that ought to be followed at all times.
But in this moment that we are talking, we've seen the administrator going about his duty. But there are those who also will say, look, if they say, according to them, and accuse the president of being complicit in what they have described as unconstitutionality in his action, what about the National Assembly? And Mr. President, let me take our viewers to what the provision of the Constitution is on Section 305, which actually allows the National Assembly within 2 days of being in session to approve whatever the declaration of the president and within 10 days if they are not sitting. But it mentions the how many, the votes that are needed to make that approval. In both chambers of the National Assembly, it provides that 2/3 is what has been provided for, 2/3. So if you look at it, there are 360 members in the House of Representatives. It means that the 2/3 will be 240. And in the Senate, approximately about 73 votes are needed to approve the decision of the president or the declaration of the state of emergency out of the 109 members in the red chambers. But there are those who have put a big question mark into the legislative procedures in the National Assembly. There are those who will say voice vote will never or should never have been used in any case. That apart from the attendance, it's supposed to be the number in the attendance, which is 240 out of whichever number of the lawmakers that will approve, and 73 or thereabout of the senators who are seated who would have voted just like you vote to review any portion of the Constitution as prescribed by the Constitution for 2/3. But let me allow you to review how the National Assembly members, the role they played. They said 243 members were in the House of Reps. The Senate also said they had a quorum, and in fact they had the 2/3.
Let me just say this: the attendance would only be relevant for purpose of ascertaining whether the minimum number of legislators in the requisite chambers were present, and for Senate that would be 73. So if there were 68, 72 That means in no circumstance would it have been able to pass it. It didn't meet the minimum threshold for that business. For the House of Reps, that would be 240, right?
Yeah, 240 for the House of Reps.
That is for purpose of attendance. For purpose of voting, because not every person may have agreed, even though they were in attendance, you must take physical vote. Each person is voting, and you tallying the votes and announcing how many voted for, how many voted against, and how many have abstained. Ayes have it does not mean that everybody shouted aye.
But
you may be a majority, but may still fall short of the total.
But
you can't assume.
Do their rules allow for voice vote?
It cannot allow for voice vote. If it does, it will be unconstitutional because the Constitution has stated the number. The ayes have it may be on issue of on which side does it appear that majority lies. On issues bordering on the Constitution, you must tally the votes and show how many voted.
Is there any provision for legislative review for whatever National Assembly members do? Because the implication of the fault or the error in the approval of the National Assembly is that it leaves the decision of the approver, so to say, to nullity.
So Shego, I've had cause in the last few days to say that if the proclamation of a state of emergency is unconstitutional, the suspension is unconstitutional. No matter what ratification you get would also be unconstitutional. It would be like placing something on nothing. It's like hot air. The declaration has to be constitutional. The suspensions have to be constitutional for there to be something to ratify. So if you ratify, even if they did a proper vote and had a 2/3, but what they ratified did not meet constitutional threshold, they would have ratified nothing.
So, but the basis for all of this is unknown to law.
That's my belief. That's our belief at the Bar Association.
So, at the moment, Governor Fubara should be acting as governor.
That's our belief. That's what we will and expect the president to do, to restore him back to power as having unconstitutionally removed him. And that's why we do not recognize that the sole administrator is a rightful person to occupy the government house in Rivers State, having been appointed unconstitutionally. When I saw him taking an oath of office, I was wondering which oath he was taking. Because he was taking an oath not known to the Constitution. The Constitution does not recognize an administrator.
But what do you do in this kind of situation as an association? Because it's an association that also acts like the conscience of the practice. So the question would be, if you find any of your members who are involved in what should guide naturally, because everyone swear to uphold the Constitution and bow to the Supreme Court when he or she is being called to the bar. And if any of such persons are found guilty or found wanting in those regards, what do you do to those members of yours?
Point is, when a member acts as a politician, as our rules of professional conduct does not apply or extend to him. That is the current state of our rules. Maybe an amendment will so make it that if you're a lawyer and your conduct brings the association to disrepute or amounts to infamous conduct, you can be disciplined. For at the moment, we must be acting in your capacity as a legal practitioner for the rules to apply to you. So unfortunately, if any member of association is found to have violated the law as pointed out, he cannot be tried for professional misconduct. And that's a great feeling on our law, because our law is still backward. There's need to bring it in sync with modern realities, where for being a lawyer, you can be disciplined for acts that are not directly connected with the practice of law.
What lesson do you think we could learn from this scenario that played out?
It shows us that there is need for us to play greater fidelity to our Constitution, to allow the Constitution to guide us, and not to allow politics to undermine the Constitution, because the whole world is watching, and the level of confidence people have in us will have a lot to do with our ability to adhere to our laws, and also for the interpretation of our laws to meet international standards.
Are we going to watch and allow what you have described to happen? Is there anything that could be done to our laws in this regard?
Our law in this regard is sufficient. It is the operators that are not abiding by the laws. So there are two different things. We don't have any gap in our law. It is our fidelity to the law.
But there is a big question. There are instances.
For example, do you mind reading Section 11?
Absolutely.
You fall into error.
Yeah.
People fall into error when they read Section 305 as if it is a standalone section.
Absolutely.
But you read especially Section 11.4.
Yeah.
Section 11.4 and Section 11 to make it clear that even in a state of emergency, the House of Assembly can still be making laws, while the National Assembly also makes laws. It's there, black and white.
No, but my question...
You may even read the proviso, just read it before. Proviso to Section 11 provided
that nothing in this section shall be construed as conferring on the National Assembly power to remove the governor or the deputy governor of the state from office.
Would you say that is not clearly stated?
I think it's in English language. but the question I'm asking is that we saw what happened when the late, when our former president, Yar'Adua, died in office. There was a lacuna in our law, and there were efforts to fix it. And there are those who say there is a big, when this kind of situation happened, maybe we didn't learn a proper lesson when former President Obasanjo took this similar action. Now it's repeating itself, and there's a lot of criticism. The president, the government of Bola Tinubu have an explanation and a defense for it. But as lawyers, and for those who are lawmakers, is there anything that could be done to make Section 305 be more explicit?
I do not believe it is not explicit. I still believe that we deliberately refuse to apply it the way it is, reading with Section 11 and Section 188. And the Supreme Court lost the opportunity in the Daria case to make a pronouncement by striking out the case on a technical ground. The court showed if people go to, I've read that some persons have gone to court, maybe many more persons would go. I think the court should clear this down by making a definite pronouncement on it. Whether he agrees with me or agrees the president or not, but let the court make a pronouncement.
Well, it can only be the Supreme Court interpreting this, isn't it?
Well, we only seem to think in Nigeria until the Supreme Court says something is not law.
I'm saying that because
if
there's a conflict between whatever decision of the federal government and the state government, I'm imagining...
So it depends. That was the technicality that arose in the Daria case, when they went to court and the administrator went to withdraw the case. And they said, well, since the person, and you're the person that are challenging your stay in office. So if the proper parties go to court, and they should be able to get an interpretation. And because it is the usurper that occupies the government of Rivers State, and there's no Attorney General in place in Rivers State, it will be tricky who can bring that action on behalf of Rivers State. So, but I'll leave that for the lawyers to figure it out. I'm not their counsel, I'm not a party in the case, so they will figure out how best to get the Supreme Court to hear the matter.
There is a proviso that was given in the amendment to the prayers on the floor of the National Assembly, where they say that in all of this, that the president should set up a committee for a political solution. Do you think that can also help in the circumstances?
That is what should have been done in the first place. It's a political solution.
But the president mentioned that all the parties involved ignored him.
No. I don't want to go into this, and permit me not to go. But I don't think people can ignore the president of the Federation if he had made the kind of effort needed to solve that problem.
Do you think he was not firm enough?
He could have given them marching orders. I think if he had been firmer, he wouldn't be lamenting.
But those who say he's firm on Fubara, he has suspended him.
Well, I may not say further about this. It takes two to tango. Let's be firm on all the parties to bring a solution.
On a final note, President, your association is not only pivotal in the role in our judicial system, and but especially in our body politic. A lot of people will believe that the NBA should be like the conscience of our society, and that's what the practice of law is actually, that it should be able to help as a compass and redirect when we are failing or where we're derailing. Do you have a feeling, because the kind of descriptions and commentaries that we hear based on the actions and the decision of the president appears to be describing as though we are derailing as a people? Do you have that sense, and perhaps where do we go from here?
I think we are derailing as a people. We are derailing as a people. People are losing hope in the ability of the executive to deliver good governance to the people, the welfare and security of the people. People are losing confidence in the legislature. People are losing confidence in the judiciary, and also by extension in the legal profession. And when we issue statements, people may say, what is your business? Why don't you allow politicians to play their politics? But I always remind them that, like Dante Alighieri was reported to have said, that the hottest places in hell are reserved for those who in times of moral crisis choose to maintain their neutrality. We have a dog in the fight. We have a dog in seeing that the society is governed in accordance with law, that due process of law is observed. And now, in keeping with our motto, which is promoting the rule of law, we should have a voice. We will say it as we understand it and hoping that it will help in shaping policy. We're not part of the crisis, but at the end of the day, we're all part of the casualties of a society that is dysfunctional, is not run in accordance with the law. So we're all affected. And we'll do what we have to do, hoping that we'll be part of the solution and not part of the problem.
Thank you. And I'm not perhaps thinking that you are inferring that said that lawyers are part of the major problems of this country. Well,
it will bury our head in the sand like an ostrich to pretend that we are not. Because most times, even when some bad decisions are taken, lawyers are the ones who give the legal advice.
And perhaps in the crisis we're talking about, major actors here.
I would not want to conjecture, but I would like to believe that lawyers were involved.